Well, good afternoon, everyone, and welcome to Wi-Fi and the Law. It looks like Lyndall and Maya, you guys having trouble hearing me, or can you guys hear me now? Oh, great. Fantastic. Glad things are working. So, you never know with government communication systems sometimes. So, we're here for our encore presentation of legal considerations for Wi-Fi related investigations. As you see at the Federal Law Enforcement Training Center, we're starting something a little different. We're trying to tweak with webinars to find what works best for our audiences. One of the things we're doing is we're asking folks to tell us who you are so we can make sure that we tailor our audiences to, or tailor our presentation to the audience. So if you're interested, go on the left side there and tell us who you are. Right now we have mostly federal law enforcement officers, some state, local, tribal guys, and a handful of attorneys and other educators. And that's how we'll do it accordingly. But really appreciate you guys doing that. At the end, we'll also do offer an option for you to receive direct emails about upcoming webinars if you guys are interested in that, and I'll tell you about that at the end. All right, let's jump into the webinars. We try to keep these things under an hour, one topic focused, and just gives you exactly what you need to know. With Wi-Fi related investigations, that is investigations where we're using analytical tools to learn things about computers through Wi-Fi. This is an area where you struggle when you're advising law enforcement because we know the technology's out there, we know it's being used, but there aren't a ton of cases that are directly on point. The problem is if you wait till we have cases directly on point, one, there's going to be a lot of officers out there running investigations not knowing what they can and can't do, and two, if you really wait for the technology to be settled, by the time the cases all tell us when the technology is okay, we've all moved on to some newer, better technology. So we're in that gray area. We have some cases. We're talking about these cases, but unfortunately, this is one where I can't tell you the answer on every situation. But I think you'll have enough here that'll give you the background and let you know when you're clearly in safe territory from the cases we have, when you're doing something that hasn't been decided by the court. And I'm also going to step back and give you a bigger view about the way the Supreme Court is tweaking with the Fourth Amendment so that you guys can see and really have a good idea so that you can make good decisions both for Wi-Fi and some of the other technology we're using out there. The last thing I want to tell you about is that I'm sensitive to talking about new technology that the law enforcement is using, and sure, the Federal Law Enforcement Training Center doesn't need to be the first one to broadcast types of technology. So I'll tell you what I'm using here, what I'm talking about here, these Wi-Fi analytical tools are things that have been openly discussed in the courts. They're also publicly available by searching on the website. There's nothing secret about the technology that's being used. It's been used in the past. It's in published court cases. So prosecutors and law enforcement of the past have decided that it was okay to go forward with a case where they were disclosing this information. So again, I don't have any opinion whether we should be more aggressive about telling the technology we're using or be less or more secretive about what we're using. I'm not talking about that. All I'm saying is that debate is not here. We're only going to talk about the cases that have talked and the technology that have been talked about publicly already. Okay, so let's jump in. We'll talk about it. Sometimes I'll say Wi-Fi simulator. Sometimes I'll say Wi-Fi analytical tools. But these are tools, electronics, programs that you can download on your laptops. You can use with a directional antenna that allow you to identify and locate certain electronic devices through the Wi-Fi signal that they're broadcasting. And we're going to talk about the cases that we have out there, and then we'll talk about some of the cases that if we want to use Wi-Fi in a different way, what's out there too. So the key with all this stuff is the rules are changing, and the things we thought we knew are not certain anymore, right? So in the cases I'm going to talk about, three of them are the big ones. One is an older case from 2001. It's Kylo versus United States. Jones is from 2012. And Carpenter came out just in June of this year, of 2018. And they all dealt with the technology, with law enforcement using technology to learn information about criminals. And in each of those cases, when the case went up to the Supreme Court, the thing they had in common is all of us in law enforcement knew what we were doing is okay. We just knew it. We knew it because we looked at the Supreme Court cases in the past, and they gave us clear tests. And when we, even though we're using brand new technology, we passed the tests they had. We knew we were okay. And in each of those cases, the Supreme Court told us we were absolutely not okay and we were wrong. And the only takeaway from that is we are in a state of flux. And I'm not criticizing the courts, but what I'm telling you is the courts have come to realize that with the advances that law enforcement has in technology, that they need to change correspondingly the way the Fourth Amendment works. And so they are changing the rules on us because the world has changed in their mind. And so in law enforcement, we got to be cognizant of that, and we got to think about it, because the stuff that we think we know may not be. And so I'll give you some specific examples of that as we go forward. Again, this is state of law that isn't changing, but I'm going to tell you where we're at today in the law today. So let's talk about the Fourth Amendment. Let's go back. I like to go back to the fundamentals on this because we get wrapped up around the court telling us what we can't do. But let's talk about what we can do. And it's that simple, that the government says, the Fourth Amendment says, that if the government is conducting a search, it must be reasonable. Government searches must be reasonable, right? They wrote it that the people are protected from unreasonable searches and seizures. Same thing, that when the government chooses to do a search, it must be reasonable. Usually reasonableness requires a warrant or a judicially recognized exception. And the warrants have to be specific or particular. It requires particularity. Most of the issues with Wi-Fi we have deal with the word search and whether that what we're doing with the Wi-Fi analytical device constitutes a search under the Fourth Amendment. And that's really important because government searches must be reasonable. But if it's not a search, then the Fourth Amendment doesn't apply. And so it doesn't have to be reasonable. I mean, we're okay because the Fourth Amendment doesn't regulate that activity. And so that's really what's coming onto is what does it mean to be a search under the Fourth Amendment? And when we're dealing in non-technology cases, the court's been pretty stable about explaining what that means. But when we're dealing with cases involving technology, the court's gotten complicated with it. And it started out with the Kylo versus United States, which started in the early 1990s. But I'm sorry, the Supreme Court case came down in 2001. And Kylo was a case about a progressive thinking federal agents and actually the Oregon National Guard. And here's what happened in Kylo. It was a drug case, believe it or not, a marijuana grow operation in the state of Oregon, back when this was a crime to grow marijuana in the state of Oregon. And law enforcement believed this Kylo was growing marijuana in his house. It was part of a triplex house. And they had a fancy new tool in the 1990s. It was called a thermal imaging device. And law enforcement didn't have it, but a member of the Oregon National Guard had access to it, a thermal imaging device. Now, this, in today's terms, this would be a very poor quality thing, a low quality device. It was a device that distinguished between hot and cold, and it was monochrome, meaning that super cold was black, warm was gray, and hot was white. And it was a device that would distinguish heat based on that. And by using this device, the guardsman pointed the device at Kylo's house and could tell that his attic was way hot. It was much hotter than the rest of his house, which was unusual, and it was much hotter than the attics of the other houses around him. And that, based on other information, made them believe that he was growing marijuana in the attic, because they knew that to grow marijuana inside, you use these heat lamps that provide heat and light, and that helps the marijuana grow. And so they believe that, and they put the information using this thermal imaging device and other stuff, and they got a search warrant for Kylo's house. And sure enough, he was growing marijuana in the attic. They arrest him, they prosecute him in federal court, and his attorney moves to suppress the evidence. Okay? And here's the thing that the court did. So now, like I told you, law enforcement knew we were okay because the Fourth Amendment up to that point was focused on cats. If the government intruded into an area where there's a reasonable expectation of privacy, then they need to get a search warrant because that's a search. But this guardsman, when he used the thermal imaging device, he was in his car on a public street. He never set foot on Kylo's property, never went in his house. And in fact, the imaging device couldn't see into the house. All it did was read the heat that was escaping the house. And there was a lot of heat escaping the house, and so they were able to infer what was inside the house. That is a grow operation. The court suppressed the evidence and came up with a new rule when law enforcement is using technology to help them learn about what's going on inside a house. And what they said was, and here's the big quote right here, whereas here the government is using a device that is not in general public use to explore details of a private home that would previously have been unknowable. Without physical intrusion, the surveillance is a Fourth Amendment search and is presumptively unreasonable without a search warrant. So the three areas I highlighted in red, it has to be a device that's not in general public use, has to be of a private home exploring, and it has to be they learned something that was previously unknowable. The court basically set aside their old rules under cats on the reasonable expectation of privacy. And in Kylo, they looked back and said, you know what? This new technology effectively allows law enforcement to learn something about what's going on inside the home. And when the founding fathers wrote the Fourth Amendment, the only way a cop would know how hot it was inside that home was if they went into the home. And so now that law enforcement is using a device that is not in general public use, then to learn what's going on inside the house, we're going to say they need a warrant for that. And so why do I talk to you about thermal imaging scanners in a webinar that's supposed to be focused on Wi-Fi? And this is it. That thermal imager was not in general public use. And you know what? Even though you can buy one off Amazon now that is 100 times better than what that Oregon guardsman's using, thermal imaging devices are not in general public use today, right? Your judge doesn't use one. It's not in general public use. And Wi-Fi analytics, many of it is pretty fundamental stuff. But guess what? It's almost certain that that is not a technology that is in general public use today. In other words, the general public is not using directional microphones or Wi-Fi analytics to locate electronic devices. And so therefore it falls into the Kylo test. And the question is, if we're using our analytical tools to learn about things that are inside a home, we're into Kylo. And even though we never physically intrude onto the property of a suspect, if we're learning about what's going on in the home, then it's possible that it's a search under the Fourth Amendment and we need a warrant to do it. That's the Kylo rule on that. So let's go into some of the cases. But Kylo helped us out because it really tweaked our rules. If you've come to the FLETC recently, you know that when we talk about searches, we tell you there are two different definitions of a search. The first is a trespass on a person, house, paper, or effect. Clearly, when you're dealing with Wi-Fi, you're not doing this. If you are, right, if you're physically going into someone's house using a Wi-Fi analytic tool, you know you need a warrant for that. Everybody knows you need a warrant for that. It's the second area that Kylo messed with, and that's what we often call as a CATS search because it came out of a case called CATS versus United States, KATZ. And that's a government intrusion into an area where a person has a reasonable expectation of privacy for the purpose of obtaining information. And what the court said in Kylo is that when law enforcement is using a device that's not in general public use to learn about an area where there's an REP, that is a search under the Fourth Amendment. And so that's the backdrop there. And we learned about Kylo with that. And then the court was somewhat dormant about the use of technology for over a decade until in 2012, Jones came along and gave us a little more information. So what was Jones? Jones was a drug dealer in the greater DC area. And what Jones told us was that law enforcement wanted to learn about him, and so they established a tracking device on his car. And they followed him around. They did not have a warrant to establish the tracking device on his car. They collected information about his drug activity. He was arrested, prosecuted in federal court, and his lawyer ultimately moved to suppress the evidence of the tracking, and it made it all the way up to the Supreme Court. And so the majority opinion, the main opinion you know about, doesn't have anything to do with Wi-Fi stuff. And it was just Scalia saying there's this old school definition of a search, and any physical trespass on a person, house, paper, or effect is a search. Basically, he said, hey, law enforcement, if you're going to put a tracking device on someone's car, you're going to touch their car, that's going to be a physical trespass, and you need a warrant to do that. That's it. So, but there were two other opinions in the case that are relevant to Wi-Fi analytic tools. Alito's opinion was a concurring opinion, meaning he also wanted to suppress the evidence, but he had a different way that he wanted to do it. It wasn't about physically touching the car. He was concerned about law enforcement and their use of technology. He said the increased invasiveness afforded by technology implicates Fourth Amendment. And he wanted to say that you can have a reasonable expectation of privacy in things even that you expose to others. And so his idea was that Jones could have had an expectation of privacy in where he was driving around the road, in the physically tracking of him, even though people could see him, because he expected privacy from law enforcement, and he did not expect law enforcement would be following him 24/7. And so Alito had actually 3 other justices that agreed with him. And so that was almost enough for a majority for the Supreme Court. And his idea was that government learning large amounts of information about a suspect could become a search under the Fourth Amendment. And even if the law enforcement never goes anywhere that's private, never steps on the defendant's property or in their house or in their car, they may still need a warrant if they're using technology to gather a lot of information about someone. And I know right now some of you are thinking, hey, Pat, you just said that's not the majority opinion, so why are you even telling me about it? And why? Here's why. There was a third opinion in that case, and that was Justice Sotomayor's opinion. And Justice Sotomayor wrote an opinion only with her, and she said that she agreed with both of the other 2 opinions. So Justice Scalia had 4 votes with him, Justice Alito had 4 votes with him, and Justice Sotomayor said, you know what, I agree with both these folks. And so she said, today I'm going to rule with the majority, meaning Scalia, you touched the car and that's the issue. He said, but I also agree with the Alito opinion. And so we learned in 2012 that there were 5 United States Supreme Court justices, enough for a majority, that wanted to change fundamentally what it means to be a search under the Fourth Amendment, especially when law enforcement is using technology to do a search. And so, and the idea they wanted to require law enforcement to get search warrants more when they're using technology to acquire information about people. And they wanted to favor search warrants more. And so this wasn't the majority opinion, but to all the prosecutors across America, we saw this and we said change is coming, right? Change is coming. And so we started playing conservative. And many of you in law enforcement probably realize that your AUSA or your prosecutor was trying to have you get warrants more often, even when we weren't sure you needed one. That was it, because we saw this. There was enough, and we're waiting for it. And from 2012 until June in 2018, the court toyed with this idea in other cases that we don't want to talk about in a 1-hour webinar. But finally, in June of 2018, the court expanded on this issue in Carpenter versus United States. Again, this case didn't deal with Wi-Fi either. And next, I'm going to talk to you about the cases that specifically deal with Wi-Fi analytic tools. But Carpenter is really on point here too. And what Carpenter told us, it was a case that dealt with tracking a guy through his cell phone. And it was, Carpenter was, he's trained, recruited, and organized guys to do robberies of stores. I call them Hobbs Act in the federal court, but to rob stores. And he robbed cell phone stores. And so he'd train the crew, he would organize them, he'd pick the location, and he would send them in to rob all the cell phones, right? You can imagine stealing 70 iPhone 10s is a pretty good haul for folks. And then Carpenter would stay out and be the getaway driver. And they did this in Ohio, Michigan, and robbed 5 or 6 stores. And eventually, law enforcement caught on to him, captured a couple of the guys that co-conspirators, and they flipped and turned on Carpenter. But Carpenter was never caught on camera, so what they did is they used a court order to get information about Carpenter's cell phone. In federal court, it's called a 2703D court order. And that court order allowed them to not track themselves, but to get historical information to learn about where Carpenter's cell phone has been. And presumably, wherever his cell phone goes, Carpenter goes. And this information, using cell site location, told them that Carpenter's cell phone was in the area of each of the 5 or 6 robberies, consistent with him being the getaway driver of the car. And so Carpenter was tried. He was convicted. The co-defendants testified. They got this information in, and he moved to suppress the evidence. It made it all the way to the Supreme Court. And in June, the court suppressed the evidence of his location, of the cell site location information, suppressed the evidence from the phone company saying where Carpenter's cell phone has been. Here's the thing about this. The court changed the meaning of search under the Fourth Amendment in order to suppress the evidence. And basically what they said is they said that Carpenter had an REP, a reasonable expectation of privacy, in the whole of his physical movements, even if that information was being tracked and stored by third parties. That Carpenter had an expectation that where he was been 24/7, and it said for at least 7 days, but it could be less than that, even if he was walking around only in public places. Why? Because 200 years ago, it would have been very, very difficult for law enforcement to track someone's movements 24/7. And so the court gave him that protection today, saying that everyone has a reasonable expectation of privacy in the whole of their physical movements. And the idea being that tracking devices, cell phone, cell site location, anything we do that tracks people, the use of technology, gives law enforcement the ability now to learn where people have been that they hadn't learned that before. And so that was it. And so now people have, when you're talking about search under the Fourth Amendment, you can talk about Jones search and cat searches, but you ought to think about Carpenter. If you're trying to get information about where someone's been 24/7 for at least 7 days, that's a search, no matter where the information is, and they have a reasonable expectation of privacy in it. So here's the other thing the court did in the Carpenter case that's directly relevant to Wi-Fi investigations. They made a new test for when people lose a reasonable expectation of privacy. So under the old rule, anytime you gave information or exposed something to another person, to the public, you lost your expectation of privacy in it. And what that meant was it wasn't a search when the government got that information. So an old school view of this, if I wrote out a confession to a crime and kept it in my house, and the government broke into my house and took that, that would be a search under the Fourth Amendment. But if I gave that confession to another person and the government obtained it from that other person, they wouldn't need a search warrant to do that, because I would not have an expectation of privacy in a document I gave to another person. Makes sense? Well, the court here said that there is a new rule for learning when people give up their expectation of privacy, and especially when people are being tracked or having information learned about them through the use of technology. And that is, they had a 3-part guidelines or factors: the extent that they knowingly shared information with another person, the nature of the information sought, and whether the information, the content of the information, is itself private. And so now they required basically that it's not automatic that you lose REP when you give something to a third party, that you actually have to affirmatively do something to lose REP. Okay? And so why is that? They changed the rules on what a cat search is again, and saying that you can have a reasonable expectation of privacy and stuff even if it's exposed to the public, as long as the information itself is private. And they told us that the location information is private information. And now there has to be some kind of knowingly, that a person has to knowingly give up their expectation of privacy and things. And so you'll see how that applies in Wi-Fi cases. As we come up next, because I'm going to show you every case that I'm aware of that deals with Wi-Fi analytic tools. So now when we're thinking about what a search is for Wi-Fi analytic tools, we have to think about the CATS analysis, which is the government intruding into an area where there's a reasonable expectation of privacy? And if so, we need a warrant for that. But if not, right, with the Wi-Fi analytic tools, we're usually not going inside an area. Then we have to look at Kylo, and we have to ask, under Kylo, is the government using a Wi-Fi simulator to explore details of a home that was previously unknowable? And so if we're using our Wi-Fi analytic tools on a home to get information that was previously unknowable, then we need a warrant for that. But if we're not, then we now have to think about Carpenter and say, does the use of the Wi-Fi analytical tool allow law enforcement to track the physical movements of a person? And if we do, if we're using our Wi-Fi in that way, and you all know that you can do some pretty good tracking of folks through Wi-Fi signals, then that might be a search as well. And if so, we'd have to ask, did they affirmatively relinquish their expectation of privacy? If we are tracking them, we'll have to ask, did they do something to affirmatively give up the right to be tracked? Okay. So let's jump into the technology of Wi-Fi, and then let's talk about the cases that the courts have announced on it. So the technology on Wi-Fi, the first thing with these analytical tools will separate the two different modes they're in, because there's a huge Fourth Amendment difference based on whether you're using these analytical tools in a passive mode versus using it in an active mode. Okay, so these Wi-Fi analytical tools is software you can download on your laptop. Sometimes you use a directional microphone or a directional antenna to help you with this. In passive mode, then your device is only observing what would otherwise be happening anyways. This is way different than a cell site simulator. The government device is just monitoring, and target devices or devices around them are broadcasting Wi-Fi signals, and this device is merely just receiving any signals that that devices are broadcasting. And so that's a passive mode. Active mode is different. In active mode, the device is causing a target device to admit or do something it wouldn't be doing otherwise. So, for example, the government pretends to be a Wi-Fi access point to try to get the target to connect with them. Pretends to be some kind of internet access point, pretends to be a non-law enforcement access point to try to get the target to connect with it. There's a big difference between when you're using these devices in passive versus active mode. Okay, so in passive mode, you generally need a court order, but the court order is called a pen and trap order. It's not a search warrant. You don't need probable cause. You really just need to have a prosecutor who cares. In active mode, you need a search warrant because you are basically exploring the inside of that computer where they have a reasonable expectation of privacy. There's a possibility that you could need more than a search warrant and need a Title III wiretap. If you're doing an active mode use of Wi-Fi devices, basically a Wi-Fi simulator, you want to talk to your prosecutor and make sure you get the right paper. Okay. So let's jump in on the cases. The most important case, the case I'm going to talk about first, is United States versus Stanley. It's a Third Circuit case. Came out in 2014. So now it's getting on 4 years ago. And as you'll see with many of these cases, they start out or they involve child pornography because they're using technology, so we're using technology to capture them. Okay, so Stanley is downloading child pornography, but he doesn't want to get caught, so he decides instead of using, or either that or he's cheap, instead of using his own internet access point, he uses his neighbor's unsecure Wi-Fi. His neighbor has a Wi-Fi point, access point and has no password on it. And so Stanley's downloading porn through his neighbor. The Pennsylvania State Police learn about the downloads using peer-to-peer software. They see it because it's visible on the internet for all to see. They identify the computer and the IP address and realize it's the neighbor's phone. And so once they get the information on the neighbor, they get a search warrant for the neighbor's house because they believe the neighbor is downloading porn, child porn through his Wi-Fi. They get the search warrant, they execute the search warrant on the neighbor's house, and guess what? There's no child porn in the house. There's no child porn on any computers in the house. And in fact, the devices that they knew were downloading child porn, because every computer has its own address, sometimes called a MAC address, has its own identifying numbers, wasn't in the house. They also saw that there was an unsecured Wi-Fi, and so they put two and two together and realized it was someone outside a neighbor's house that was downloading Wi-Fi from the neighbor. And so what do? They did not initially password protect neighbor's Wi-Fi. They actually left it unsecure, and with the neighbor's permission, which is an interesting conversation, you think, when you execute a search warrant on somebody and then realize you got the wrong guy, and now the neighbor helps you get the right guy. And they used a Wi-Fi analytic tool called Moocher Hunter, which is one of my favorite names for any software, to track down the location of the computer and the MAC address that was downloading child porn. And so they use Moocher Hunter. They use it with a directional antenna, which basically, when plugged in, it helps locate or identify the strength of a signal. And so they learn by using it and following it that the signal is coming from Stanley's apartment. So they get a search warrant for Stanley's apartment, and sure enough, that's where they find the child pornography. And so Stanley, after he's prosecuted, he moves to suppress the evidence that obtained from using this Wi-Fi analytical tool to locate his computer that was downloading child porn through its MAC address, which was broadcasting through Wi-Fi. And the court declined to suppress the evidence, even though Stanley was arguing about Kylo, which I talked to you about in the beginning. And Stanley was saying, look, law enforcement was using technology to explore the inside of my house to figure out if there was a computer in my house. And that's exactly what they did. And Kylo, in court, you should suppress the evidence. But the Third Circuit in Pennsylvania said, no, look, Stanley, when Stanley wanted to access his neighbor's Wi-Fi, he intentionally broadcast the signal of his computer outside of his house to the neighbor's house in order to get free Wi-Fi so he could download child porn. And since he knowingly exposed his computers by using the neighbor's Wi-Fi, he did not have an expectation of privacy. So despite Kylo, the evidence of Wi-Fi should be suppressed, or should not be suppressed, because Stanley did not have a reasonable expectation of privacy in a signal he intentionally broadcast outside the house. And if you look at the Carpenter case we talked about, it actually follows, the language follows very well. It wasn't the fact that law enforcement was looking inside the house, because that was an issue, but the fact that Stanley had intentionally exposed, had knowingly exposed to the world his MAC address so he could broadcast it to the neighbor to get internet access. He had no REP. He did something intentional that took away his expectation of privacy in the use, in the location of his computer in his house. And so Stanley was the big case. And that tells us, and we'll talk about Broadhurst too, but if somebody is intentionally broadcasting the signal of one of their devices outside of their house, and we're using Wi-Fi analytic tools to locate it, then we're okay. So anybody stealing Wi-Fi, right, that's knowingly sending the signals from their computer outside of their house, we can receive or intercept that signal without needing a search warrant. Okay, Broadhurst is an Oregon case as well. Again, child porn case. Deputies know that child porn is being downloaded again through an unsecured Wi-Fi in a home near a school. Same thing happened in Stanley. They locate it to a neighbor. They get a search warrant for the neighbor, and they realize it's not the neighbor. Someone was using the neighbor's Wi-Fi without permission. They used a different type of Wi-Fi analytic tool. The last one in Stanley was called Moocher Hunter. This one is called the Shadow. Again, it's something that's available to the public, and they locate a strong signal and determine where the device is that's stealing Wi-Fi. They're able to identify it's a particular house. They get a search warrant, and sure enough, they find child pornography. The district court in Oregon followed the reasoning that Stanley had, even though the Oregon one was before. They worked together, and they said that using Shadow to monitor Wi-Fi signal strength in a neighborhood, there's no reasonable expectation of privacy, particularly for Broadhurst, because he was trying to hijack his neighbor's Wi-Fi. The idea of reasoning here is Kylo did not apply because Broadhurst was intentionally sending a signal from his computer outside his house. And since he was intentionally sending it outside his house, he could not have an expectation of privacy in the signal because he was intentionally sending it outside the house. And again, they looked at Kylo and held that Kylo did not apply here. Okay, so that was Broadhurst. Norris was a third case, 2013 out of California. And I'm showing you this to show you that even in the Ninth Circuit, this rule seems pretty solid. It was another situation of Norris stealing Wi-Fi from a neighbor. This time they used Moocher Hunter, which was the same one they used in Stanley, to locate the defendant's Wi-Fi device. They had Moocher Hunter in passive mode, and the court said that use of Moocher Hunter was not a Fourth Amendment search. And again, defendant had no reasonable expectation of privacy in signals he was sending to neighbor's Wi-Fi access point, which he didn't have permission to use. Okay, so what do we know? The limited thing we know about Wi-Fi analytic tools is if you're tracking down someone who's stealing Wi-Fi, or someone who's intentionally, even if they're not stealing, if they're intentionally connecting to a Wi-Fi location that is outside their house, you can use the analytic tools in a passive mode to locate that device. Okay? But what happens if we're using an analytic tool to find someone who is not intentionally broadcasting their Wi-Fi locations outside of their house? I'm sure if you go outside my house on the public street, you might pick up MAC address for computers in there. Because we are broadcasting our computers to access our Wi-Fi device, our access point, our router that is inside our house. And so we are not intentionally broadcasting it outside. What about those cases? Well, you know what? We don't know yet. But what we do know for certain, if a subject is intentionally broadcasting their MAC address outside of their house in order to access a Wi-Fi point, that we can use analytical tools to identify their device. If they're not doing it intentionally, then I think you come into the Carpenter rule. And the Carpenter rule dealt with that the individual has to knowingly expose something to the public. And merely having a device that happens to broadcast outside would not meet the Carpenter knowingly test. So if you're trying to identify a MAC address in a house who is not intentionally trying to broadcast their address outside the house, these cases would suggest that's a search under the Fourth Amendment. And so you want to talk to your prosecutor about what type of paper you need, whether it's a search warrant or some other type of a pen trap from the court to identify that information. Okay. What about, you're not stealing Wi-Fi, but what about a public Wi-Fi? What if they're not stealing, but they're connecting their MAC address to a public Wi-Fi? Either they're sitting in the cafe, they're sitting at Starbucks, they're connecting to a public Wi-Fi. I think that there's no cases on this either. But when you look at the Stanley case, the Broadhurst case, the Norris case, and you look at Carpenter and Kylo, I think it's pretty clear that where we're at, and that is the question is, are they knowingly broadcasting something to the public? And so here's what I'd ask you. Can you explain to the court, if I take a normal computer and I connect to the Starbucks Wi-Fi, can I see the MAC addresses of all the other people that have connected to that Wi-Fi? If I can, from an ordinary computer, not using special stuff I downloaded from the internet, not using Mutual Hunter or Shadow, but just using that. If I can, then I don't think they have an expectation of privacy in the identification of their MAC address. If they're in a public place and they're broadcasting in a public place, then I think it's hard to argue that I have an REP. And if they're intentionally accessing a public Wi-Fi, a legitimate Starbucks Wi-Fi, then they probably do not have an REP, and therefore we can identify their devices without it being a search under the Fourth Amendment. But we don't have a case that says that. I just given you the cases that we have and kind of letting you look at that and see. But clearly Kylo doesn't apply, because Kylo only applies if we're trying to look into an area where there's an REP, particularly looking inside a house. So that's where we're at on Wi-Fi stuff. So now let's talk about, some of you may, when you think about Wi-Fi analytic tools and Wi-Fi simulators, you might want to compare them to cell site simulators and the cell phone analytical tools. And they're not the same thing. So, and they're hugely different. A Wi-Fi analytical tools, Wi-Fi simulators are actually less troublesome from a Fourth Amendment perspective. And here's why that is. So when you use a cell site simulator, you're using that device to simulate a cell site. And cell phones work different than Wi-Fi, even if your Wi-Fi is on your cell phone. I've seen that the cases that talk about cell phones being a dumb device. And what cell phones do is they're constantly looking for the nearest cell tower. And when they're looking for a cell tower, they want to connect their phone to whichever cell tower gives them the strongest signal, the closest tower, this tower that has the best signal. And they will automatically attach to that one with the strongest signal. Well, when law enforcement uses a cell site simulator, they become that strongest signal. And the cell phone will automatically connect to the cell site simulator. And that means that law enforcement is making the cell phone do something it wouldn't normally do. Automatically connect to the cell site simulator. And it has implications. It may make it so they can't make a phone call. But because, even without that, because the law enforcement simulator device is causing that phone to do something different, that is likely a search under the Fourth Amendment and is a triggerable event. But Wi-Fi is different, right? Wi-Fi doesn't require any phone to connect to it. Wi-Fi just gives you that option. And so if law enforcement is using a Wi-Fi simulator, all they're doing is broadcasting the availability of the access to the internet, but they're not making any computer or any phone required to connect to it. Because of that, they're less troublesome under the Fourth Amendment. In order for someone to connect, they have to make an affirmative choice to connect to that Wi-Fi device. And so therefore, they're doing that intentionally, and it's more likely they're going to give up their reasonable expectation of privacy. Now, one caution, if you're thinking about doing something using a Wi-Fi simulator and doing it in a way where you're going to disguise that it's law enforcement, right? Put up a fake site and pretend that you were some company that is setting up that site. Talk to your prosecutor, because there's a couple issues in that, and I'd rather not even go down that road, because whether you want to try to do that will really depend on what jurisdiction you're in, what judges you are, and how much risk you and your prosecutor want to take on that. Okay, so Wi-Fi simulators in Carpenter, you're probably okay. And the Carpenter case, which is going to have huge implications for us in all different areas of law enforcement using technology, but probably not Wi-Fi, because generally these Wi-Fi analytical tools we're not using them to track the physical movements of a person. Now, could you? It's possible that you could. And if you're using Wi-Fi analytical tools to track 24/7 the location of a target, then you're square in the middle of Carpenter, and you should have a warrant. Clearly, if you're doing it for 7 days, and likely if you're doing it for less than 7 days. But under an active use of this Wi-Fi analytic tools, then maybe it would be. And so you just got to keep your eyes open. If you're using it in a way where you're tracking the physical movements of a person for a long period of time, then you are squarely in the heart of Carpenter. And I think it's unlikely that the court would say that someone has given up their reasonable expectation of privacy in their tracking, just like Carpenter didn't give it up in the tracking of his cell phone. And if so, if you're getting 24/7 information about the location of your suspect for a long period of time, days, then you're probably going to need a warrant for that. All right, so try to keep it short, 45 minutes. I've told you, I've given you the cases that are out there, talked a little about the language, also given you an idea to think about the use of the next technology, which may not be a Wi-Fi analytic tool like Moocher Hunter or the Shadow, but might be something new. As always, you want to talk to your local prosecutor, because when you're using technology in criminal investigations, you're entering uncharted territory. There really is, the case law is always going to be behind the technology that law enforcement is using. Always. Because we have to use the technology, we have to catch the guy, we have to prosecute him, we have to introduce the evidence, we have to find an attorney that is smart enough to try to suppress the evidence, and it has to get to an appellate court. And so we'll always be using technology that is years ahead of when the courts start telling us about it, which is why we're really just looking at the beginning of these cases, and we've been using these Wi-Fi analytic tools for some time. So that's my address, and be happy to talk to you further. Please, if you have any questions, type in them. One last thing I want to do is set up this poll here. If you have any interest in receiving email advertisings about when our upcoming webinars are, just type your answer into the poll here, and we'll put you on a list, and we'll send you, it'll be rare, infrequent, but we'll send you notices of upcoming email addresses. We still broadcast through the Informer, and if that works for you, then great. Don't do it. We'll continue to do that. It's just what works for me is, you know, I read the Informer and I think that looks good, but it's not. It's hard. I get it a month ahead of when the webinar is going to be, and I figure sending a reminder shorter in time, you know, earlier. You know, it's coming in a half an hour. We're going to have one tomorrow. Might be easier for us to remember. So if you want that, go ahead and sign up, and we'll add you to our list, and we'll put you on it. Also, if you have any thoughts or topics about webinars you've been looking for, or say you got a group of folks that have a particular interest in a webinar, let us know. And if you have more than one person listening on you right now, please let me know, because we track our stats on this stuff. So we hope you enjoyed this webinar. Hope you have a happy holiday season, and if you ever need anything, reach out to us at the Federal Law Enforcement Training Center. We're happy to help. Thanks, everybody.